So, welcome to Contracts for Paralegals. I'm so excited to teach this course. When I was in law school, I actually got the highest grade in contracts. So, when that happens, you get what's called an American Jurisprudence Award, and that's something that stays with me for the rest of my life. So, in all of my life, I will always know that I won an American Jurisprudence Award in contracts. My contracts teacher was very, very, very good. So I learned a lot from him. He did not do what they call hide the ball. He was very straightforward. So I enjoy teaching contracts. A couple of years ago, I was asked to do a little redesigning of this course to make it easier for you. So I think that the way the course is set up right now, as long as you follow the syllabus and you follow the lesson plans, you will have no problem passing the course. Contracts is actually, these are sophisticated legal principles, but the way Rasmussen University has your curriculum laid out, you'll have no problem passing the course. So let me introduce myself to you. My name is Catherine Dove. I'm an attorney. I went to law school back in the 90s. I got my bachelor's degree at Virginia Tech in political science and philosophy, which is kind of a good background leading into the study of the law because, as Aristotle said, everything's politics, and law is also very political. It is created by elected officials, and it's created by judges who are either appointed or elected. So the law itself is very political. So having a background in political science helps me to understand it. When I was an undergraduate, I also had a legal studies minor. So I started reading the Constitution in detail, I would say about 30 years ago. So I really know a lot about the Constitution, the legal principles, and the history behind the law, and that makes it easier to understand the law. So I am excited about teaching this course. I've been teaching since 1998, which was not only in the last century, ladies, it was in the last millennium. There have been a lot of changes since then, and most of them have involved technology, but the legal principles themselves have not changed. In America, contract law was brought over from England with the original colonists when they settled in Jamestown, Virginia, and Massachusetts, and the places where they settled first on the East Coast. They brought with them the history of the English common law. So the common law existed in England, and that law has been brought over. So much of our contract law is derived from the old English law. So these are very, very old legal principles. They are not new, which makes me happy to know that there is a certain validity, and there's actually a lot of very solid and established legal principles that will not change. And contract law is very well established. The Supreme Court is not going to rule in contracts law tomorrow in any way that's going to change anything that we do with contracts. This is all a very stable area of the law. So we're going to start out with a basic introduction to contracts. And all of you probably deal with contracts in your daily lives. Has anyone ever dealt with a contract? Feel free to unmute yourselves. A lease, a sale agreement, purchase real estate. Have any of you, Alyssa, Yamalitza, Janine?
I own a house and I'm married. Those are both contracts, right?
Yes. Yes, usually purchasing real estate involves several contracts. It involves, a possible loan, a home loan. It involves a lien being placed on the property. It's a secured transaction. And then there's the sale purchase agreement and the closing. So all of you have dealt with contracts. So before we get started, ladies, let's have an introduction. I would love each one of you to just introduce yourselves in the class and just give me a little more information about your background before we get started. Alyssa, can you go first?
Absolutely. So my name's Alyssa. I am 24. I live in Florida. So I am on the Eastern time. So it is 8 o'clock here. I am currently a judicial assistant in Seminole County, and I am loving every second of it. And my paralegal associate's degree is actually helping me be successful in my job.
That is so awesome. So what does a judicial assistant do, Alyssa?
So I do a lot of calendaring for the judge. I process orders, prepare orders for the judge, answer phone calls from pro se litigants, attorneys, all the fun jazz that the judge needs me to do, handles emergency motions and foreclosures. You name it, we do it.
That is so exciting. And yeah, the knowledge here is just going to benefit you in your career. And you may be a judge one day yourself. You know, it's not out of the question. When I was practicing law in California, one day a senior partner in our firm was asked to be the assistant or the substitute judge in small claims court. She took me with her. So we both presided over small claims court one day in California. We heard landlord tenant disputes, and I had never expected myself, you know, to be sitting there at the judicial bench doing anything. So you might be a judge yourself one day. So this training will be excellent for you. And coming from me, it's all practical knowledge. You know, since I've worked as an attorney, I've worked with paralegals, I've worked with legal secretaries, you know, and I've had to appear in court and work with judges before. So everything that we discuss this term will be very practical knowledge that will help you, Alyssa. Thank you for that introduction. How's the weather in Florida?
It is very hot.
I grew up on the East Coast in Virginia, and I've been to Florida. One of my best friends from high school was in Tampa. I loved seeing her, and they're doing all the fun things that you can do, going to all the museums, going to Clearwater Beach, and, you know, just going out and doing all the fun stuff. But it was so humid. I was like, 90 degrees and 90% humidity is killing me.
Yes, and now it's summer, so when it gets really hot, it rains all the time.
That's so crazy. Thank you for that introduction. Let's hear from you, Yamelitsa. How are you doing today?
Hi, I'm doing really good. I'm in Florida also. I'm in Newport Richie, so it's raining over here. Um, it's Florida summertime. um, my name is Jamilita Charneco. I am 27 years old. I work for the legal department at Progressive. I'm currently a legal assistant there. Love what I do. Doing the program at Rasmussen has been helping me to develop my skills. So I love the dual, being able to work and take the classes. Um, been doing legal assistant and paralegal for the past 5 years. I'm originally from Puerto Rico, so my English, I have a really thick accent. But I love what I do. It's pretty good.
That's awesome. I've taught other students that worked at Progressive, and I almost went with Progressive for my insurance, but I got a cheaper rate with Geico because I'm keep thinking, man, I should just, you know, I have students that work at Progressive. I need to go with Progressive. You know, I got a cheaper rate at Geico, but I did some insurance defense work as an attorney for State Farm and Farmers. So worked on some car accident cases, some fender benders, and that's very steady work. So you're in a great area. And
In
it should you
Florida,
just,
it's full of accidents.
yeah, yeah, you will have no trouble, you know. And
Yeah.
one day I'll tell you more about my experience at working in insurance defense. But yeah, it's very stable and good work. And if you should decide to go to law school and be an insurance defense lawyer, you make a lot of money.
Uh,
And so that's terrific. So good to have you in the class. Janine, give us a brief introduction, please.
Okay, hi, I'm Janine. I am 41. Just turned 41 2 days ago, on July 3rd.
Happy birthday.
Thank you. I'm currently on vacation in San Diego. So I have family that's in San Diego and I have family that's in Hawaii. So I try to get out to both locations at least once a year to visit family. In addition to that, I have my own family. I have 4 kids of my own. Me and my husband recently separated like in December, and he's got 3 kids. So I have 3 stepchildren, and then so I have all the kids. And then I'm a professional bartender. So I've bartended my whole life. 23 years I've been doing it. And I just decided probably about a year ago when I came into school that my body's not going to do this forever. I'm going to have to retire at some point. and I should probably just have a backup plan. So I decided to go to school to be a paralegal. I've always been interested in law, and it's always been something that intrigued me. So I was just like, I'll try it out and see if I like it. So, I mean, I currently work 4 jobs, 3 different serving and bartending jobs, and I also clean houses, 4 kids, school full time. Busy, busy woman over here.
Wow. Thank you so much, Janine, for taking time out of your busy schedule to attend this live session. I hope you're enjoying your vacation in San Diego. So I went to a law school at the University of San Diego, and that's a pretty good legal market for paralegals. So if you should decide that you want to work as a paralegal, San Diego is a great place to do it. And the law firms are all boutique. They're all very nice and very beautiful. So that could work in as a plan for you.
I
And
definitely read it online, and I was like, oh, I wonder if there's like some remote positions right where we're, San Diego, but still be in Minnesota, because I live in Minnesota, so that's where I'm from, Minnesota, but that's where I live. I'm from San Diego, but I live in Minnesota.
that's great. Yeah, those are both really good, strong legal markets. So that's terrific. Thank you so much for telling us about your background. And yes, and what's ironic is some people go to law school when they graduate, they end up working as bartenders. So you've already worked as a bartender, so you can do it the other way around. You can decide that I don't want to do this job anymore. Now I'm going to be a paralegal. Maybe you even decide you want to go to law school, and you'll already be done with bartending. So
Yes.
that's so
Bartending is
wonderful.
great. It's a fantastic career. Like, I love it so much. But, like I said, 23 years, I think it's not necessarily ran its course, but my body's not going to do this forever. My body's like, okay, we're done.
Yes.
Let's just calm down for a little bit.
Yeah, I'm so glad. The law has so many applications. It's benefited me personally, the knowledge of the law. It's benefited my family, me knowing the law, in addition to the fact that it allows you to take on some other jobs. You may be able to go from 4 jobs to 2, and those 2 jobs might actually be enough.
That's the goal.
I'm here for you, Janine.
Thank you.
Yes. Is there anyone else? I know we had one person on the call, but I think we lost them. So if there's anyone else that needs to introduce themselves, I think we have everyone covered here. Let's get on with our lecture. This will be somewhat interactive. The only reason that I'm lecturing is because there's certain principles in the law that we just need to talk about. Can everyone see this PowerPoint slide?
Yes.
Yes.
Awesome sauce. I wish I could make it bigger, but I think this is as large as it's going to allow me to make it. So I'll get back to this stuff here. The first thing we're going to do is talk about some of the fundamentals of contract law. Then we'll get to our module 1 assignments. And it looks like they got my head in the PowerPoint slide. But so the first thing we do in the law when we're talking about anything is we get a definition. Because if I say contract, Janine, and an apple comes to your mind, but when I say contract and an orange comes to my mind, we're not talking about the same thing. And that's what a lot of discourse is like in America, and why we have so many problems is that people are not communicating effectively. So the first thing we have to do is get down to a definition that we can agree on. So a contract is a promise or a set of promises for the breach of which the law provides a remedy, or the performance of which the law recognizes as a duty. So a contract is a promise or set of promises that are enforceable. The party to the contract or the offeror, the person who makes the offer, and then the offeree, the person to whom the offer is made. So those are some basic definitions. The next thing that we do in the law is we establish the elements, which are the requirements that must be met to establish the existence of a doctrine. In order to establish a contract as a matter of law, you must show the judge that there's been an offer, acceptance, and consideration. If you have those 3 things, your contract can be enforced in a court of law. It does not have to be in writing. Because again, contract law came from the English common law, and it doesn't have to be in writing. Contracts can be oral. So an offer is an expression of an intent to be contractually bound to specific and definite terms. So if I say, I offer to sell you my blue book, Uniform Code of Citations, for $50. Janine, what would you say? I'll ask Alyssa. Alyssa, if I offer to sell you my blue book, Uniform Book of Citations for $50, what would you say?
Yes.
Okay, that's acceptance. Acceptance is a promise or an act of a party indicating a willingness to be contractually bound according to the same specific indefinite terms. So once you say yes, and the court finds that we're bargaining for something that has legal value, which is the $50 has legal value and the book has legal value. So that is a contract. Offer, acceptance, and consideration. There was a manifestation of a willingness to be contractually bound. Alyssa accepted that, and the court can find that we were bargaining about something of legal value. Period. That's a contract. Contracts may be written or oral. What Alyssa and I just formed was an oral contract. Written contracts may be easier to enforce or prove, but an oral contract is perfectly provable. And if you've ever watched any court TV, has anyone ever watched Judge Judy, Judge Million, Judge Mabel?
I love Judge Judy and Judge Million and Maybelline. I love all of them.
And the other one is Hot Bench. I like that show, Hot Bench. So yeah, a lot of times what people are in there, Janine, trying to prove is an oral agreement. And for Judge Judy, she's going to be like, let me see your phone. Let me see some emails. Let me see some text messages. Do you have anything written down on a piece of paper? Let me see the lease. So, they're looking for the proof that a contract exists. And then what the judge is looking for is evidence of the terms. What are the specific indefinite terms? So here is another type of oral contract. The contract that Alyssa and I just discussed, that was a bilateral contract. I promise to sell the book and she promises to pay for it. A unilateral contract is when one person makes a promise and the other person performs. Uni means there's only one promise. That's why it's called unilateral. It's not that it's one-sided. It's that one person is exchanging the promise for the performance. So here's an example of an oral unilateral contract. Anne talks to her neighbor's son. His name is Bob. Asks him if he will mow her lawn for $20. Bob doesn't say anything. He's not talkative. But he does put gas in his lawnmower. He pushes it over to Anne's house and he starts mowing her lawn. Has a contract been formed, Janine?
What did you say to me?
Has a contract been formed if Bob starts to mow Anne's lawn?
It has been formed, but I'm very confused about that because it's a verbal contract. So, like you said, with Judge Judy or Judge Millian or Judge whatever, they want to see the contract. And even Judge Millian is like, even if you take a piece of toilet paper and write it on a piece of toilet paper, it's a legal binding contract. So, like, how do you prove a verbal contract if there is no? So, I read that earlier and I was like, I'm so confused.
Okay, let me clarify that. Contract is like many concepts in the law, Janine. It is not a piece of paper, it's an idea. A contract is a legally enforceable set of promises. It does not have to be in writing. So forget about thinking of contract as a written document. It is not. It is theoretical, like so many concepts in the law, like a tort. It's not a pastry. A tort is a civil wrong. It's not a piece of paper. It's not a pastry. That's a tart. And contract is the same way. It is a theoretical concept, like a stock. A stock is a piece of intellectual property. It is not in writing. Cryptocurrency is really is intellectual property. It is intangible. Same as stock, it's intangible. Copyright is intangible. A patent is intangible. A trade secret. The formula to Coca-Cola is a trade secret. It is intangible. It may be evidenced by a writing, but it is an intangible concept. So that contract is actually an intangible concept. It is a set of promises that are legally enforceable. How do you prove a contract? Two people can go to court and testify as to the terms, and the judge looks at the evidence. You do not need a writing. So if Ann promises to pay Bob $20 for mowing the lawn and he starts mowing the lawn, that is a unilateral oral contract. Oral contracts are fine. Now, how do we prove them? The court says that direct testimony and circumstantial testimony are evidence. So testimony, if the judge believes me, my testimony is just as good as a piece of paper that has the terms of the contract written on it, because a judge can determine your credibility by looking at you. I'm not perfect, Janine, but I can usually tell if somebody's lying during a testimony or an interview. Liars look off to the side. They won't really look you in the eye. They blink a lot because they're trying to think of a liar. They're looking off to the left. So liars do things that a judge can tell and also if something is logically incoherent that someone's telling you, if it doesn't fit the story. If Bob said, if Ann says, I don't know why Bob was over in my lawn mowing, Judge Judy would be like, well, did you ask him to mow your lawn? No, I was just watching soap operas. Well, why did he come and mow your lawn? Oh, my lawn needed to be mowed. Well, did you talk to Bob's father? Yes. What did you talk to Bob's father about? Having his son mow my lawn. Oh, okay. Well, there's an oral unilateral contract. So through testimony, an oral contract can be established by looking at the parties' actions, circumstantial evidence, and who is a credible witness. So a contract is intangible. It is a concept. It would be nice if they were always evidenced by a writing, like a lease or a real estate a mortgage contract, but they don't have to be in writing. So that's how. So again, getting back to me and Alyssa, if Alyssa promises to pay me $50 for my blue book, and I promise to sell it to her, that doesn't need to be in writing, because we both go testify before Judge Judy or Judge Million, and she finds out who's lying. So does that make sense, Janine?
That makes a lot of sense. Thank you for explaining.
Yeah, my bachelor's degree is in philosophy and political science. Philosophy is really about considering a lot of intangible concepts like virtue, ethics, intangible. So that understanding of the intangible really helps when you're looking at legal principles, because certain ones are intangible that they really can't be touched. The writing is simply evidence of it. If we have an agreement to purchase stock, for example, stock in Apple computers, that's a company that's doing well. So if I decided to sell you 10 shares of stock in Apple computers, that stock is intangible. But there might be a stock purchase agreement that's in writing and that can be printed out that we could look at that would evidence that agreement in the contract, and it would evidence the value of that stock, which is otherwise intangible. So we will be, in the law, there are certain concepts that are intangible. They're theoretical. Okay, let's get back to the real world. So a complete legal offer. So also when you're looking at legal concepts, there will be elements within an element. So we said the elements of a contract are offer, acceptance, and consideration. Now we're going to break it down even to the next step. We're going to analyze, well, what's an offer? The offer can also be broken down into 3 more elements. An offer is a promise of future performance, a description of what each side gets, and a way to determine which side has to perform. So that would be an offer. For an offer to be valid, it would definitely need to have specific and definite terms, and it would need to tell the offeree what they need to do to accept the offer. So I think your module 1 assignment is going to ask you, whether something is actually an offer. So you'll need to go back when you're writing your memo and say, well, to have an offer, you need to have a promise of future performance, a description of what each side gets, and a way to determine when each side has to perform. And it's usually within a reasonable time. So when you're doing legal analysis, you start out with the rule, and then you take the facts of your case, you put them together, and that becomes your legal analysis. You start out with the rule, offer acceptance consideration. Well, what's an offer? It's a promise of future performance, a description of what each side gets, and a way to determine when each side has to perform. So you look at your set of facts and say, has an offer been made? And it's marrying the facts with the law, and then you reach a conclusion. So I believe next week we'll be starting to talk more about the IRAC form issue. When you identify an issue, you come up and research the rule, you do your analysis and reach a conclusion, which is a lot of what what you're doing as a lawyer or a paralegal or someone who is studying the law. If a client walks into your office and says, I have a legal problem, and you're like, well, what's your problem? And they say, well, all of this stuff happened and I want to sue my boss for sexual harassment. Well, the first thing that you have to do is go to Lexis and research and find out what sexual harassment is from the legal perspective. We've heard a lot about TV about who sexually harassed whom. You know, it's a trendy term these days, sexual harassment, sexual assault, sexual abuse. Yamalitza, do you know the difference between sexual abuse and sexual assault?
I actually don't. Isn't
Yeah,
sexual abuse physical, like they do the act, and sexual assault is um when they molested you? I'm not sure of it.
you're close. You're very close. And sexual harassment, those are three completely different things. Rape is a fourth completely different thing within the law. So if a client walks into your office and says, my boss has sexually assaulted me or sexually harassed me, the first thing you have to do is get a definition of sexual harassment. Yes, sexual assault is usually, or rape, that involves a penetration, and a sexual abuse, sexual, see, I'm getting confused. Rape involves a sexual penetration. A sexual assault may not involve a penetration. It depends on the state law in which you live. Just like statutory rape is defined differently by each state. That's goes back to the way our system of government was formed under the Constitution. We have a federalist system with a strong federal government. States still have rights, and it's the same thing with the abortion issue. States have the right to decide whether or not someone can get an abortion. States have the right to decide how crimes are defined. States have the right to decide how, sexual assault and these issues are defined. So you would need to get on the internet and find out how sexual harassment is described. And from a legal perspective, sexual harassment in the workplace is only two things. It's either a hostile work environment or it's quid pro quo, where someone has to exchange sexual favors or dates to keep their job. So if your client comes into the office and says, I want to file a sexual harassment suit, okay, well, was there quid pro quo? And no. Well, was it a hostile work environment? No. You don't have a lawsuit. You need to leave this office. So, those are the kind of things that you need to know, as a paralegal, a legal assistant, or an attorney. You need to know what the legal definition of these terms is, and again, sexual harassment is something very specific. When you find out what the definition of sexual harassment is, it's either quid pro quo or it's a hostile work environment. If your client's facts do not meet those standards, they don't have a lawsuit and you have to wave goodbye because you can't make any money off that case. So that's why we're going to spend time looking at the definition of legal terms and the elements that comprise that term, so that when a client comes in your office, you'll be able to marry the facts of their case with the law and do a solid analysis of whether or not you have a case that you can actually win. Does that make sense?
Yes, it does. I was like, oh, okay. It's really different.
Yeah, everything in the law is actually very precise. It is not, the kind of confusion that we see in society. That's why people get educated in the law. We focus on specifics. We get down to definitions. We take time and we analyze it. We develop critical thinking skills. Trust me, when I was in high school, I had a tiny little bit of critical thinking skills. Now I'm 50 years old. I've been doing this legal stuff for 25 years. Yeah, my critical thinking skills are very, very deep, and they're very precise, and they're very accurate. And that takes time to develop, and that's what we're going to work on. Is your critical thinking skills, your skills of analysis, and really knowing, do you have a case you can win and make money off of? So there is a written contract, Janine. Contracts don't have to be in writing, but certain contracts, it would help when you're dealing with a lot of money. So let's talk about an enforceable contract. If an offer is accepted, it immediately becomes a contract that is enforceable in court. An example is a clothes washer purchased on a rent with an option to buy or rent to own plan. I did that when I got out of law school. I got a job in Colorado. I moved to Colorado. I didn't have a lot of furniture, so I went to a rent to own place because I wanted a nice fancy bed. So I got one that I had to, rent to own, pay a certain amount each week. And there was lots of tiny details and interests and all that. And it was in a written agreement. So in a rent to own situation, the seller has to deliver the furniture described in the contract at the time of the contract, or whatever is the time that is specified in the agreement. There cannot be any uncertainty about the item being sold, which is the consideration that we're bargaining for. So if the rent to own place says that they have a nice bed set of furniture for $1,000 and I can rent to own that for $50 a week, those are specific and definite terms, and there's a description of the Daydream black furniture, whatever headboard that I'm ordering. That's all specific and definite, and those terms would need to be in the agreement. The offer, the dollar amount needs to be filled in, the exact times of payment, because if it's an installment contract, those types of payment need to be specified. So that would be called a secured transaction because the seller has a security interest in that furniture. And if I don't make payments, what happens? If you're renting to own furniture, Alyssa, and you don't pay, what happens? If someone has a rent to own agreement and they're renting furniture and they don't pay, what happens, Janine?
They go to court, small claims, people go after them.
Before that, what does the
Um,
furniture company do if I don't pay for that furniture?
They go and get their furniture.
Yeah,
They're gonna go
yes.
and get it.
There are statutes that, because that's called a secured transaction, meaning that they didn't just give me that furniture, they have a security interest in that furniture. And if I don't make my rent to own payment every Friday for $50, they can come and repossess that furniture. And there's statutes, written statutes that govern that entire transaction. We'll be looking at statutes this term. So they would follow the statutes in terms of, repossessing that furniture. And for the most part, that's going to be enough because they have the security interest in the furniture. And as long as they get the furniture back, they're happy. Now, if there was like a large outstanding balance that I owed, I would either pay that or they could possibly take me to small claims court or something like that. It'd be the same thing when somebody purchases a vehicle. If you buy a car from Chevy and Chevy finances it, they maintain a security interest in that vehicle. As soon as somebody does not make the car payment, Chevy repossesses the car because they have a security interest in the car. Same thing about buying a house. If you buy a house for cash, that's awesome. You own it. But if you buy a house in Wells Fargo finances it. If you miss a few house payments, Wells Fargo can come back in and foreclose on their security interest in the house. So that's how a secured transaction works. That's also a contract, and that's all covered by specifics within the law. So the most important thing to do is to remember is an offer has to have specific and definite terms. If you have a contract that is in writing, it needs to include those specific and definite terms. The subject matter, the consideration needs to be described, the money, the item, the time for payment, the time for delivery, all that needs to be specified in the contract. Any questions? Excellent. Let's take a look at an example. Suppose that Bill wants to be hired by Ron and June, a married couple, to paint their house. All of the terms are oral, except for a brief unsigned bid. Pay Ron and June signing on their house, $1,500 for labor, homeowners to pay for supplies to be completed this summer. Is that a complete offer? The rest of the terms are oral and include information such as it has to be a workmanlike job. Bill has to scrape and paint with a primer and use a finish coat. He must paint using the paint that Ron and June choose, and Bill needs to bring his own ladders. First of all, is there an offer? Alyssa, is that a valid offer? Anyone think that this information is enough to say that there's been an offer?
I think that it is because they're letting them know, hey, we're gonna pay you $1,500 to paint our house, and the owners will need to supply everything else. I don't think it's completely clear as the rest they did it oral, but at least for the amount. But it doesn't even establish a time limit on when he's supposed to finish the job.
This summer, and I
Oh,
mean,
the
I think
summer. Okay, yeah, the summer. So
reasonable people. Yeah.
I think so.
I know. I keep reading it over and over.
Yeah, me too. I'm like, I think so. Yeah.
I think that the law favors the enforceability of agreements. The Constitution says no state shall pass any law impairing the obligation of contracts. I think the law presumes and it favors the enforceability of agreements. With that in mind, I think that this is enough to say that there has been an offer made to contract. I think Judge Millian, Judge Judy could look at this and say, okay, these people have it. Bill is going to paint the homeowner's house. They're going to pay him $1,500. He's going to paint the siding. They're going to, they're going to choose the paint. He has to use the paint that they choose. He's going to bring his own equipment. He's going to do it sometime this summer. I think that Judge Millian would say that's an offer. And if Bill shows up and starts performing, that's a unilateral oral contract. Because all of the terms are not necessarily in writing. It says the terms are oral except for a brief unsigned bid. There's a contract here. There's enough evidence, circumstantial and direct, and the actions of the parties. If Bill actually shows up sometime that summer with his ladder and he starts painting, that would be evidence of him accepting the offer. So no, I think that there is enough here to say that there is an enforceable offer to contract. He can accept that by promising to paint the house this summer, or he can accept it by showing up with a ladder and some paint. Any questions?
No, that makes sense.
No,
Awesome.
we good.
We're making progress. Great. So your written assignment for this week, there's a client interview about an oral contract. So you're going to be a paralegal in your module 1 written assignment, and a client's going to come into your office, and the client's going to give you some information, and it's going to ask you how you would conduct an interview. Based on your own words, why might an attorney recommend that an oral contract be put in writing, even though an oral one is valid and there are witnesses? You're going to read the client interview that's provided in Module 1. How do you feel about the way the paralegal did the interview? What would you change? If you were the interviewer, would you use a printed intake form, mark it with handwriting? So I think it would be helpful if I went into the online classroom and looked at the, and we took a look at the assignment. So let me get a web browser here. Share. What I want to share is, I want to share a web browser. So hang on just one second. I'm going to open up a web browser. We'll go into the online classroom and get some more information about this assignment. So don't go anywhere while I do this. I open up the classroom, make sure I don't already have it open, and I don't. Close that. I'm going to go into Blackboard and we'll take a look at this assignment. Oh, good. Awesome sauce. So share. Can everyone see the Blackboard classroom?
I can,
Yes.
yes.
Awesome. So this course, our learning management system is Blackboard. We're starting out with Module 1. If you would like, there are some very helpful contract flashcards here that I always recommend. This is a great way for you to learn some of the basic definitions of the contract terms. There's the word, and then you click on the arrow. Contracts may be. So yeah, just take some time and work on that. Let me go. So you can do that on your own time. It just is a way to help you study contracts using those flashcards. Module 1 assignments. Written assignment is the complete offer. So let's take a look at our scenario here. Okay, scenario. This assignment will use a client interview to apply the basic law of contracts to a case. The goal is to determine the validity of a contract. Paralegal is greeting a client after they have talked to the attorney. The clients say, let me tell you what happened. Leo, the owner of Riverway Construction, said he would re-roof our house for a lower price than what anyone else bid. We showed him a bid from Right Fixed Construction, which we thought was a good bid, but he studied it for a while and he smiled. We don't know why he smiled, but we think we do now. Leo and his crew said they could redo the roof for $6,500, which was less than what the other company had bid. So the homeowners were not satisfied with how this worked out when they saw how he fixed the roof of their house. So they've hired a lawyer. And the first question for you is, why might an attorney recommend that an oral contract be put in writing? Talk about the client interview. If you were interviewing a client, would you use a printed intake form? Would you mark it with handwriting? What other method might you use to take notes? So I'll just ask you this question. So if you're a paralegal and you're interviewing a client, how would you take notes? Any ideas?
We usually actually print the form, or we use a form in Word so we can type it in.
Excellent. Yeah, that seems to be very helpful. And me, embracing modern technology, I think you could do something on your tablet. I think you could do something on your phone. If the client allowed you to, I think you could record the conversation with the client. Just tell the client, well, do you mind if I record our interview? You could go back and listen to it later. So I would definitely, I always try to, really think outside the box when it comes to how you might take notes. If this is a case that's important to you and you don't think you can write down everything the client is telling you, record the conversation, record your meeting with the client, just get their permission, record it. Use technology. Most cell phones have a recorder. Just record it, and then you can listen to it later, and you might even come up with some ideas on how to approach the case based on what the client said in the interview. So what would you ask a client in an interview like this? Any ideas? Your client comes to you and says that they're not happy with the way that the construction company fixed the roof on their house. Well, what would you ask the client? Well, you might ask the client, did you pay for it?
That would be the first thing. And I will ask them if they were specific about the work that they wanted done, if they had any pictures, or they show something to the contractor of what they wanted done. Because sometimes they say, oh, yeah, I want pink and blue. Yeah, but what pink and blue you wanted? Did you show him? Because maybe the pink and blue that his definition is not the same. So I will go into more detailed questions.
Yes, everything is in the details. That's very good. So yeah, you could think of some follow-up questions, and the assignment is just saying, recommend 3 open-ended questions. So an open-ended question is like what, who, where, how. A leading question is when an attorney says, you're lying, aren't you? You could think of somebody in court when an attorney says, you killed her, didn't you? That's a leading question. When we're talking to a client, we want to use open-ended questions to get the facts out. And then what happened next? Do you have any pictures? Did he email you? Did he ask you if you were happy with the work that he did? You want open-ended questions. How, what, why, where. Question 4, based on what you know so far, was the oral agreement based on a complete or an incomplete offer? Argue both sides. And again, that's what people in this society don't do enough, is try to see the other point of view. There's always 2 sides. One side may not have as much evidence in support of it, but when you are working as a legal professional, you need to know what the other side is going to say. You need to anticipate what they're going to argue so you can run in court and be ready to challenge anything that they say. Be ready to answer their argument. So when you're considering whether or not this is an oral agreement, a complete offer was made to repair this roof, you want to argue at both sides. Well, the evidence weighing in favor of a complete offer is he did agree to do it for $6,500. He completed the work, so that must have been based on somebody's belief that there was an offer. We did state that we wanted to have our roof done, and he did complete, he did build a roof and whatever. And then you want to argue, but on the other hand, you could argue that it's an incomplete offer because there is nothing that says whether the soffits and fascia need to be completed. There's nothing that says what quality of roof. There's nothing that says when it has to be done, blah, blah, blah. So argue both sides based on the lesson notes. If there's an area of uncertainty where we need more information from the client, say that. One way to approach this assignment is to use this application table. I want to, can you still see that screen?
No.
Awesome. So, what I'm going to do now is I'm going to open up this document called the application table. The assignment says that you can use an application table to better help you understand and approach your analysis. So let me go into my files and I want to open up this application table. So I want to look at documents, desktop, documents. Cancel. Cancel. More actions. Share. All right, I'm back in the online classroom. So download the application table. I'm going to download the application table and then we'll take a look at it so long as I can get it to open up on the screen, which I think I can. So you can use this application to help you. Okay, everyone see this application table?
Yes.
Awesome. So you want to fill this in. Questions. Here we go. Do we need to ask follow-up questions? What should we ask? Authority for using a writing signed by the parties. Discount from the contractor's other bid. Is it just an oral bid for the roof? Do we need to ask any follow-up questions? Roof replacement was done. Soffits and fascia were not done. What follow-up questions should I ask about what was said about the roof fits and fascia? When was this billed? Should I ask about bills? The lesson states in an account stated. Consider using that. So there's an issue about whether there's an open account here, whether the client still owes her the bills, whether there could be a lawsuit brought for that. Do I have to interview? So go through this and try to complete this table. And once you've completed this table, then you want to write your paper. That's the main focus, is to write a 3 to 5 page memo with at least 3 references. So those references should be cases that you find on Lexis or cases that you find on Fastcase. You can cite to an online treatise about the elements of a valid contract or why we should have a contract in writing. You could research something on the internet about the elements of an offer. Make sure everything is formatted according to Blue Book standards. So let's take a look at the Blue Book standards. So for all of your assignments in this course, you're going to be required to use the Indigo Blue Book. The Indigo Blue Book is a manual of legal citation. So when you're citing to statutes, cases that you find, you'll want to use the Blue Book format. Full citation. So here's a case citation, the name of the parties, the name of the case citation itself. This stuff in parentheses refers to the court, Southern District of New York. 1999 would be the year that the case decision was rendered. Here's another case. The parties were Toolson versus the New York Yankees. This case was heard by the U.S. Supreme Court in 1953. It appears in volume 356 of the Reporter on page 356. So this is the volume number. A lot of these cases were historically put in books. So when you see these numbers, this is the volume of the book that you would have to go touch in a tangible library if you were doing that. And you would turn to this page in the book and you would find this case, Toolson versus New York Yankees. We'll be doing all of our research online. So if you're looking for a case, that's your citation. this is the year of the case. So this is the kind of blue book format that you want to use when you're discussing a relevant case. So if you get on Lexis and you find a case that talks about an oral contract to repair a roof, you can start to make analogies from this case to that case and say, well, in that case, the court held that there was a valid offer. So the court will do the same thing in our case. If you want to do something like that, just be sure to use a blue book site for the case. And you need 3 references for this assignment. Any questions? Everyone's still here?
I'm still here. No questions. Thank you for
Excellent.
explaining it.
You're welcome. I'm here to serve you always. I work for you. So,
I appreciate it.
yes, ma'am. I don't think a lot of teachers understand that we work for you. The school pays us, but you know, they pay me to work for you. So let me go back to this PowerPoint presentation, and we were going to wrap up this fantastic and productive live session. Open. Here we go. Going back to this slide presentation after this live session is over, I will share with everyone the link to the recording as well as this slide presentation. So let's get back to, so our assignments for this week, we're meeting right now for our live session. Your written assignment that we just described on the complete oral offer is due Sunday at midnight Central Standard Time. So again, you have the option of using the application table to compare incomplete and complete offers and identify the characteristics of a complete offer. The table will help you apply facts to the assignment scenario, apply those facts to the law. Quote and cite a portion of this week's lecture notes as one of your 3 references. Your paper should be 3 to 5 pages in length, double space. So that means 1.5 to 2.5 pages, and then you double space it. So you double spaced 3 to 5 pages. So that's less than single spacing, double space. 3 references formatted according to Blue Book standards. And see the rubric for details on how your assignment will be graded. I'll be sure to post the grading rubric. And just a reminder, every week on Wednesday at 7 p.m. Central Standard Time, we'll be meeting for this live classroom session. This is a great opportunity for you to get to know your classmates and ask questions. I look forward to seeing all of you next Thursday. If you have any questions or concerns, feel free to email me, call me. My number is 702-241-3415. You can text message me at any time, even in the middle of the night, if that's when your question comes up. Any questions before we wrap up this Module 1 live session? Thank you, Yamelitsa, and thank you so much, Alyssa, for attending the Module 1 live session. I will see you in cyberspace.
Thank you. Have a good afternoon.
Thank you so much, Yamelitsa. Bye, Alyssa.
Bye. Thank you.
You're welcome.